This conference will now be recorded.
It's now 6:32 on April 26, 2021, and I hereby call this meeting to order, and we'll conduct a roll call, which I think I forgot to do last week. I'll just call your names, and you can make a noise and noting that you're here, but I can see all of you, so it's not brain surgery. Okay, Gage Hunt.
Here.
Christina Lucero.
Here.
Carter Tannehill.
Here.
Paul Roberts.
Present.
Frank Robbins.
Here.
And myself, Rob Durbin. I'm here. Okay, so that's everybody, and so we're good to go. All right, do we have, let's see. It looks like Letha, you might be the only citizen out there watching tonight. Do you have anything you'd like to address before we start?
Oh, I'm just here for the comments and where this charter is going.
Just here for the fun, huh? Okay, thank you.
Fun.
Okay.
I'll mute now. Thank you for asking, Mr. Durbin.
Okay. Mr. Davila, you had sent me some comments and ideas, and I've incorporated them into this week's stuff. Hard to call it a packet at this point, but the material I sent out for today. Do you have anything you'd like to add before we get rolling?
I don't have anything to add, but if anybody wants to ask me any questions, I'd be happy to answer them. And if I answer them, this is going to be strictly as a resident and not as a council member.
Okay. If we have something we might need you to do or discuss with you regarding your role as a liaison, we can talk about that too as well, can't we?
Yes, sir.
Okay.
And Mr. Judge Durbin, the same goes for me.
Yes, ma'am. I was just coming to you next. I was trying to get them all out of the arch first, and then I could just say ditto. Okay. Based on that, one of the things that I think we've got pretty good circulation amongst the council members, because I got comments from Arch and I got comments from Councilman Sullivan, and I've got a little bit of input from Ms. Marion. So I think we're in pretty good shape from the council. But I think part of our charge is to discuss and kind of evaluate with the city some how it's operating as well. And I don't want to get into a big old breach of the who can talk to who stuff again, but at some point I think we might want to perhaps ask Roy for any input he might have, and I know he would probably appreciate that as some sort of a formal request so that he can prepare and show up. Is there anybody else in the city that you'd like to talk to? Mr. Robbins?
Yeah, I've been asking Erin last couple of meetings for her input.
Well, she's sitting right here. She can talk anytime she wants to.
Well, yeah, this attorney stuff. We ought to get some of this stuff in writing.
Okay,
and that,
well,
Mr. Chairman, that may be part of the sort of preparation of the packet and timing of same. You're getting input from folks and we're not hearing any of that. So if we get input, how do we know what those folks have said and are able to look at it in a timely manner?
Well, I'm happy to provide the emails, but I've incorporated them into the documents as best I can. And hopefully, Councilman Davila, you'll see, and hopefully I incorporated what your ideas, at least what the issue is. I didn't want to get into a discussion or a debate tonight. I just wanted to let everybody know what your idea was. And hopefully I did that with some accuracy.
Mr. Chairman, if a council member gives you an idea, let me say, as opposed to an idea that comes from a committee member, I would like to know that it's the council member's point.
I fully intend to tell you that, that it's on here, and when I address it tonight, I was going to fully tell you that this came from Councilman Davila, or this came from Councilman Sullivan. I don't want to keep any secrets, and I'm happy to forward you the emails as well, Frank.
Well, Mr. Chairman, that wouldn't be for me alone.
Yeah, I know.
But your point that as we go through this, in one of the documents that you sent out, you could indicate that this came from X. That's great. That's fine.
Okay. Well, I mean, we can. It's.
But don't that's an issue, I think, for the entire committee. So, but if you're incorporating and we can know that here's the idea, that's fine.
Okay. Okay. And that's what I intended, because a lot of times they're putting their arguments and things like that, and we're just not quite ready for that particular. We're just not ready to get that far down the line yet. We're not arguing or debating at this point. Yeah, Frank.
Oh, shoot. I'm sorry. I knew this was likely to happen. What you're indicating is that, and I'm guessing that you're getting you're getting reasons for X, Y, and Z from others.
I did.
But we don't see that.
Would you like to? I will forward. I'm happy
I think
to forward the emails.
The whole committee ought to see that. The reasoning behind what someone wants to change, I think, is important to all of us.
Of course
I get that from Paul. Paul, for instance, when Paul made his comments to us in the track change document, I get a sense of why he wanted to change it, and that's helpful to me. So I would, when we're visiting about this, and folks say something, this is why I want to change it, that's helpful.
Of course it is. Yeah. Why don't we, can I make a suggestion? And that is, we go through it, and if you have issues afterwards and you still don't think I've given you enough information, let me know, and we'll just go from that point, rather than argue about it before it's a non-entity yet. Fair enough? Okay. All right. The first thing I'd like to do is, and last week we went through articles 1 through 4, and before we start, I will revisit potential new articles or new sections that don't really have a place to fit in at the moment. We talked about defined terms last week, and I think everybody understood what that was, and whether we need to have them or not, we can discuss later. We also talked about the city's official name. That was something that is in other city charters. I can't imagine anybody would find it offensive that we state the name of the city in the charter. So for the benefit of all and brevity, so hopefully we don't have to fight about it later, I did insert it into the end of section 1.01. If you look, you'll see a red line underlined version there. And all I put was a sentence said this was the official name of the city is the city of Lago Vista, Texas. And if we can, I don't know that, does anybody, yes, Frank?
Well, I think you're going to answer the question I think that I was going to ask. If nobody says anything about your red line, your track change of the document, I assume that means a consensus. Is that correct, Mr. Chairman?
Well, we're not going to vote on it. I'm not going to change anything. It's going to stay a red line until we actually vote on it. Okay. What I'm hoping is that we find some consensus on some of these, that we more along the lines of issues that we might be able to remove. So
consensus to remove.
Consensus to remove, but
okay.
in something as simple as this, or a grammatical change or a spelling change, hopefully I can see some heads nod and I can leave it in there. And at some point we will vote on that particular section in whole once we get to the end of this, because we still have information and requests coming in. I'm not ready to vote on anything yet, because I think we'd wind up having to do it over again later. Is that fair enough? Heads? Thank you. Okay, does that work for you, Frank?
Yeah.
Okay. All right. And then last week there was also somebody had asked about should there be any reference to the comprehensive plan in the charter. I don't think we added it anywhere. They didn't make any suggestion for where it ought to be. Mr. Hunt, I think that might have been your suggestion. If you would like, you want to add to that, or it may just be a discussion point, which we have some
actually,
of those.
Do I have the option to remove that suggestion?
Absolutely.
Then consider it done.
Okay. All right.
I think that discussion is a bridge too far for this particular version of the charter review process.
Okay, thanks. All right. I will. Okay. Now I received another discussion or a suggestion, and this came from Councilman Sullivan, and that's D on number 1 of the suggested areas of change, and that was council members that in the past council members have participated in council discussions for which they filed a conflict of interest form. They didn't vote, but they did participate in the council discussions. Apparently most council members remove themselves from the dais when those issues are being discussed, but it doesn't appear to be anything in the charter, and it doesn't appear to be a requirement. His issue on this related to Councilman Bartholow, and I believe it was probably a airport ordinance or the contract with the POA or something up there, in which he was Mr. Bartholow apparently filed a conflict of interest form, but then participated in the discussion, and Mr. Sullivan felt that may have prejudiced the council in some form or fashion, and I'm completely open for discussion on this one. Frank.
For me, it's a part of a bigger picture, because we've got what? We were talking about a lot of work. 40, 50 different changes. One of the issues we're going to have is this going to be a long ballot. And so I'm thinking through some of this as stuff that we don't need to change if we don't need to put it on the ballot. and trying to maintain some flexibility for the council, particularly if they already have a document that relates to an issue. And so I don't think this one needs to be changed or added to, because the council can decide how they want to deal with letting council members be involved. Now, I agree with Kevin, but I think it's too much detail for the charter.
Okay.
And I know what he's, and you and I, at least Rob, you and I probably know which one he's talking about. There's more than one, but I think it's too much detail for the charter.
Well, he did mention the Bartholow incident, so I wanted to make sure.
Yeah, that's an example, but I think that's something that the council needs to do with the ordinance that addresses how members will deal with issues of this type. And we have the ordinance, so I would amend the ordinance or add to the ordinance rather than the charter. That's all.
Yeah. If there is an ordinance on this, then I'm of like mind. I believe that the charter can, or the council can and should govern itself if they can do it in a fair manner. And I'm at least willing to give them the opportunity to try to mess it up. But until they do, I will give them the benefit of the doubt that they can set their own rules on this, in my mind. Mr. Roberts, do you have a comment on that?
I agree with sentiments that both of you guys are speaking to, and want to remind everyone that, you know, our charter, to your point, to both your points, our charter is intended to be broad and give the council the leeway it needs to write its ordinances the way it sees fit to address the minutia, the finite details such as this. And we unnecessarily delve into those details. That's not the role of the charter.
No, it isn't. It is not. But it is also not necessarily to give council the widest possible leverage or ability to do what they want. It's otherwise we could have a one paragraph charter that says council can do anything that state law lets them do.
I agree. I think, but as it pertains to Councilman Sullivan's suggestion,
I agree too. Yeah.
Should we
our door key
leave it out and let's move on?
Okay. Anybody, Mr. Tannehill, were you trying to get in there? Oh no, that's Gage. I'm sorry. Gage, were you trying to get in?
No.
No?
No.
Okay. All
Mr.
right.
Chairman.
Yes.
So 1.1803 of our Code of Ordinances addresses conflicts of interest, and so that's where the appropriate language would be. It does not strictly prohibit participation. All of this is a derivative of Local Government Code Section 171, which requires the local official to file before a decision on a matter the conflict of interest affidavit. Right. And it requires that they abstain from further participation in the matter if, in the case of that particular interest, it would have a special economic effect on the business entity that's distinguishable from the general public. So I think the language in the state statute is what is really important to recognize, that it says you have to file the affidavit and you have to abstain from further participation in the matter, which would indicate that you should not be participating in the discussion.
Potentially, it's hard to tell without definitions of what participate means. So, and that may be defined in the government code, but I don't know. But I do think there might be an issue. I mean, any councilman is still a citizen. So, you know, that as a citizen, I don't want to shut him up too much. But in any case, I believe that's the council's purview, and let's go ahead and move on. Mr. Robbins.
Well, I still think it doesn't need to be in the charter, but I agree with Kevin. If a member of the council remains in the room during the discussion, his vibes and other body language are going to affect, and that's participation. So I think they ought to leave, but let's put it in ordinance.
It ought to be in the ordinance, whatever.
Yeah.
Okay, we're not doing council's job for him. That's not our role. That's not our role. Okay. All right.
I'm going to close, get one sentence there. I have to disagree with Mr. Robbins on one point. I think that any citizen of this community, whether they're on the council or not, if there is a conflict of interest and they have to recuse themselves, that citizen still has freedom of speech, and no ordinance can infringe upon that. And if that city councilman has had to recuse himself, he can speak in public comments in a manner that he sees fit pursuant to his interests. And I personally don't think an ordinance should have him leave the room, but that is a discussion for the appropriate agenda item at city council on that ordinance.
Okay, let's and with that we will leave it and move on. Okay, I agree with Mr. Roberts, okay. Now, just tracking the charter, we go down to the next red line, and we had some discussions about the annexation in 1.04 last week, and I don't think anybody was Frank, I believe it was your issue, and I don't believe anybody really objected to the ability of council to be able to annex property that it owns. If the city somehow goes out and buys a chunk of land that's not in the city, they ought to be able to annex it. There may be some limits you want to put on it, because, you know, if they buy a chunk of land in Oklahoma, I don't know that we want it. But and that's the question: is there any sort of training wheels do we want to put on that? But I went ahead and took a shot at some language, and feel free to criticize it. I have no pride of authorship, but what I had done was say that the city, by annexation by city council, the council shall have the power by ordinance to annex any city-owned property, comma, any property adjacent to city's boundaries. That would there should be an or in there, I believe. For some reason, I thought there was another, but if there's an or in there, is that language look appetizing or objectionable to anybody, Mr. Robbins?
No, however, I don't know if the issue about owned property is actually an explicit state law or court-made law. And Aaron said that's how you could do it, but I don't know which one it is. So the issue for me on annexation, the simplest thing to do, and the bigger issue, Mr. Chairman, has to do with, again, the detail in the ordinance or the charter. If state law changes, and then do you have to go back and change the charter, or should one go back and change the charter if state law modifies it? And I think the technical answer, Aaron, is you don't have to, because the state law is going to rule, and you can kind of correct that later. And so the language for, and Mr. Chairman, I don't know, the language might be that can annex in accordance with state law, and just leave it that way or something like that. And that, I don't think prohibits us or ties us in any way more than we need to. But I'm okay
Well,
with what you said because that's what we were told was okay at the last meeting.
well, and that's what, and I was trying to address a problem that or an issue that I thought had come up, and make it in accordance with what we were told. And the solution may be just to stick in there, so long as so we can leave these training wheels on, because you never know what state law is going to say, and then say, so long as it's in court and not in conflict with state law. Because yeah, if the state creates the legislature creates something, it's going to trump whatever we say anyway.
Aaron, is this state law or is it court-made law? You're muted.
You're muted, Aaron.
Sorry, I'm keeping my thing muted mostly because they are working on the AC units here and it's making an awful noise. So I'm sorry if it sounds like a giant is banging in the background. It's partially both.
Okay.
The 43012 of the local government code gives type A municipalities the authority to annex area that it owns. And by ordinance, I'm looking to see if it references home rule, if it makes a statement with regarding to home rule municipalities. I was double checking that. Home rule municipalities have the following authority under 43003: fix their boundaries, extend the boundaries, and annex area adjacent to the municipality and exchange area with other municipalities. So it doesn't explicitly say annex the area that you own, but I know that has been applied, and that has home rule municipalities have done that. And so I'm expecting that's codified in case law, because I'm not seeing it explicitly in chapter 43.
Now, I've not seen anywhere in our charter that we can exchange, in the charter anyway, that we can exchange with another municipality. If that's an option, that might make sense to stick in into this section. I honestly hadn't thought of it till you read that little section there, Aaron.
Mm-hmm.
Yeah, that may lead back to in accordance with state law statement.
Well, my point is I don't know what state law would allow them to do in the future, but currently I'm okay with the current law, and so I don't mind stating it. But do we want to state the council shall have the power by ordinance to annex any city-owned property, any property adjacent to the city boundaries, or any property exchanged with another municipality?
Yeah, boy, I'm sorry, guys. If you say exchange, that connotes that you might be able to exchange land we don't own or that's contiguous.
Well,
so can you do that?
It probably would, but I'm just throwing it out there. I mean, if that's not power you want, if that's not within the broad realm you want to give to the city council, I'm okay with that too. Mr. Roberts, I saw your camera come back on. You got any thoughts on this?
Away from the conversation for about 3 minutes.
Oh, no problem. I thought you popped back in to tell us something.
No,
impart wisdom on us. That's okay. Okay. All right. I'll leave it out for now. If somebody has other suggested language, then or wants to address that exchange stuff, let me know and we'll put it back in. But at the moment, I'll leave it out.
You got in other words, you're saying that we're not going to make the change?
What change?
Well,
No, I'm the only thing I'm leaving out is what I brought up tonight, which was exchanging property with another municipality.
okay.
Because I didn't hear any support for that amongst anybody. Okay, but if some develops, let me know and we'll bring it back up. But at the moment, I will leave this in as it is, and if we need to polish the wording a little bit later, but I think we all are on the same page that it's any city-owned property or any property adjacent to the city's boundaries. Okay, we had no suggestions on disannexation, so let's move down to 201. I added some language that I thought was appropriate in there that just seemed to be conspicuously missing when I read through it again. I added that the city is a home rule city. I didn't add that. I'll let you know when I start adding. Accordingly, the city shall have full and complete power of local self-government and all authority powers, both defined and implied, that are not inconsistent with state law or this charter. Okay. Does that make sense to everybody? It does to me. Otherwise, you could put a period at the end of state law and we could all go home, because that gives them as much power as the state will give them. And I don't think that's what we intend. Ms. Lucero, you popped in there? Nope. Okay.
Just an agreement.
Okay. Does anybody have any objections to that addition? Or this charter? Hearing none, I will move on. The city shall further have all other additional authority and powers now or hereinafter granted to home rule cities by state law. And I added including but not limited to, and then made that list, because otherwise it looks like the A through N is all that they can do, and they can do more than that. Does everybody feel like that was an appropriate addition, or that it was out of bounds to do so? And a thumbs up from Ms. Lucero, thumbs up from Mr. Roberts. Okay. Hearing no objections, I will move down to
Before you get to 2.02.
Yes, we're at 2.02 now.
Just right above that, in the letter M, preserve and promote the health, safety, and welfare of all local citizens.
Yeah, I saw that. I saw that, and I didn't add it, and I was hoping you'd bring it up. And this is just I think if you add all local citizens there, you get into a deal where some local citizens may be adversely affected, as opposed to you can't please everybody all the time is kind of the thing I'm thinking there. So that's why I didn't add it, but I know what you're saying, and if you want, I think you could probably speak to it as a more general term, and rather than a bunch of individuals, and say the welfare of the local citizenry or something like that, that kind of speaks on a communal level. Speaking on a communal level is not my forte. So if there are any suggestions, I'm certainly willing to listen to them. But I didn't have any problem with the way it was written, because I think there's always a balancing act, and sometimes sometimes you know, the good of all at the expense of one. And, you know, I don't want to wind up quoting Spock here from some bad Star Trek movie, but that's kind of what it sounds like. And I think that's what you run into when if you try to say everybody.
Yeah.
But that's why I didn't add it. But I know what you're saying, and I appreciate it. And does anybody else have any comment on that in that regard? No. Okay.
Perfect.
All right.
We can move on.
Okay. Thank you. 2.02 under the general powers. I think everybody was pretty. A lot of people thought this was poorly written, and certainly that one where they got tongue-tied saying it was possible to list them, but they, for some reason, decided not to. I struck that and put that it would be impractical to list in this charter. And I was begging for everybody's understanding in that. I just couldn't come up with a better phrase, but as I said, I have no pride of authorship, and I'll listen to anything you want to stick in there. But anything's better than that goofy stuff that was there.
Rob, it's not goofy.
Okay, okay.
But yours is better.
Okay, fair, okay. I'll take it.
Yeah, the issue for me is I know the guy that wrote the charter, and he and I have been through this, and some of this is his legalese, and it's hard to understand. I grant, and so it's better. In practice, it's better.
Well, I represent a lot of oil and gas guys, and if they can't understand it, they won't sign it. So yeah. I try to distill out as much legalese as possible, but being a lawyer, at some point it all makes sense to me, and it may not to somebody else. So feel free to scream out whenever you see any legalese.
I appreciate you for doing that, Rob.
Okay, but
hey,
and I know you have some other points. Yes, Gage.
Yeah, I'm going to step offline for a moment and go in a few minutes I'll rejoin by video.
Okay. All right. We'll try to go slow. No,
I don't want to slow progress down. Move it
all right.
as
Go
fast
ahead.
as you can. Thanks.
Right. Quick like a bunny. There you go. Okay. The eminent domain paragraph. I don't think there were any changes suggested in paragraph 1, but in paragraph 2, it looked like somebody had kind of yacked up a handful of commas, and at least 2 of us, although we wanted it to say the same thing, we couldn't agree that it did. So again, I tried to remove some of the confusion, and I rewrote it stating, the city shall not, however, use the power of eminent domain to acquire land owned by a property owners association and used as parkland by that property owners association members, which is, I think, what we were all saying last week, but we couldn't agree that that's what the thing said. Mr. Robbins.
That's the point. And so you're on track. I'm on track with we need to fix what it means. And so I think you've changed the meaning. And Erin is nodding her head.
In what way?
I think the meaning is that the city can't use eminent domain to acquire a property owners association owned by a property owners association, period. Or there's a comma there. But the city can't use eminent domain if they are going to dedicate it and used as parkland. Now,
Well, if they don't need eminent domain if they're going to dedicate it.
well,
When they dedicate it, that means
I don't think this precludes the city from using eminent domain to acquire POA property that's used for something other than a park.
I thought that's what this was. I mean, I don't have a problem if it says they'll not use power of eminent domain to acquire the property owners association, but I would worry about that. And I think I thought the intent was property owners associations are going to be comprised of citizens for the most part, and if the POA is going to provide parkland for them, the city won't take that land and use it for park or anything else.
I agree with that, but I don't think that's what you said.
So I would, Mr. Chairman, caution the change that you've made, because it does take away the city's authority to take by eminent domain that property that the city may need for non-park purposes. For example, if they need to take by eminent domain a strip of property that is currently owned by the POA to put in a water line or a wastewater line, I would not recommend that we take the city's power to use eminent domain to take that property for that purpose.
I understand.
My understanding of the prior intent was that the city can't take POA property and then use it as city park property.
Okay. All right.
So the city can't steal the POA's parks and then use it as city parks.
Right.
I think that's my understanding, that if that's what the goal or the intent of that particular section is, the way you've reworded it, the city would not have the authority to do the proprietary, the governmental functions that it may need with regard to other things.
I get it. All right. It's not, that's not a thought that had crossed my mind. I was looking in my head for some situation where they might need to take parkland for some other reason, but for roads or something like that. And I get that. I don't have a problem with that. Okay, then, but I don't think that's what it said before either. So I do still think we need to change the wording. Used as parkland by that property owner association. Can we say something like it's unless it's for for a city's right-of-ways or utility easements or something like that? I mean, what would I'm trying to get there, and
I'm okay as written, Rob.
I don't think it's written. I don't think it's understandable as written. I mean, it does not say. Basically, all it said before, and I'm not even sure. I still think it had an extra comma in there, or two extra commas. But basically, all it said before was it couldn't take the POA parks to use as city parks.
Right.
Okay.
That's all it meant. I think that's what it means.
But you can take it for anything else?
No. I mean, my point is, it's okay as written. And as I understand what it says, it's just the way you said it. Now, could you rewrite it to say it simply the way you just said it? Yes. City can't use eminent domain to buy parkland from a POA and use it for parkland. I mean, how many different ways can you say it? I'm just okay with the way it's written, but it can be improved.
I understand, and I think that we were talking about being really careful with the citizens and the POAs here, and I still want to be deferential to those folks. And I don't think that the intent is to say that you use eminent domain to take that property owning association park and use it for anything, for anything. I mean, I think for just anything. I mean, I think the property owners association would be, and plus you've got a big issue with semantics there as to what's park. I mean, if the city takes it and sells it to a private organization to put in a resort or water theme, a bunch of its own boat ramps, or is that a park or isn't it? Okay, I guess my question is do we need to, how specific do we need to be as to what they can take it for?
You don't.
Yeah.
Public purpose is eminent domain, and that's a pretty broad term, but I like.
Well, I know, but it's a very broad term, and it's been used for all kinds of things and abused all over the country. What was all that talk last week about being deferential to the, we got to be really careful here and what we're doing, because we're going to tick off the POA members. I thought we were all on the same page, is that we were trying to protect the POA's property in terms of it, since it's being used as essentially park for the citizens of the Lago Vista, of Lago Vista now. Most of them, or some of them, do that. We certainly. I don't know. I mean, last week you seemed differential to them. This week, I think you're basically saying, screw it. We want to put a little mall out there at the end of Cody Park. Let's go ahead and and they decide it's a good idea. We can appropriate it for that.
Mr. Chairman, I object to that characterization of what I've been trying to say.
Okay.
All I'm saying is that the city ought to have the authority to use eminent domain. And eminent domain, it doesn't need to be the list of things that you can do with eminent domain under the term public purpose is unnecessary. The example that the city attorney has given us are some of the reasons we need to have eminent domain authority for things other than its use as a park, roads, utilities. And I'm telling you, folks, we've gotten real close to needing to do the utility stuff.
Okay.
And so Rob, I don't know how much longer we want to do this, but I think it's written as okay. Now, don't characterize me as wanting to do a bunch of other stuff for the POA. Thanks.
Okay. All right. I'm not saying you're going to do a bunch of stuff for the POA, but you'll. Okay. My apologies. It's not time to debate it. Okay. I'm just going to highlight that paragraph, and in my mind, it needs to be rewritten, and we can figure it out later. I'll just put rewrite completely off to the side. Is that fair enough? Giving city right to eminent domain for necessary well, I'll come up with some wording later. It's not working now, but I don't think we're going to resolve it now. Does anybody else have any thoughts on that issue before we move on? Nope. Okey doke. 2.04 zoning, there's no changes. 2.05 rights reserved. I had some comment that this paragraph needs to be more understandable. Again, this is something that is it's pretty legalese, but this is one that actually made sense to me. So I don't taxes. Let me just read through it, make sure that I don't miss what the person was trying to get to me. All suits, taxes, penalties, fines, forfeitures, and other rights, claims, and demands of every kind and character which have accrued under the laws in favor of the city, heretofore in force governing the same, shall belong to and vest in the city and shall not abate by reason of adoption of this charter, and shall be prosecuted and collected for the benefit or for the use and benefit of the city, and shall not be in any manner affected by the taking effect of this charter. But as to all such rights, the laws under which they shall have accrued shall be deemed to be in full force and effect. The budget and all ordinances, rules, and regulations of the city shall remain in effect, subject to the terms of this charter and the full discretion of the vote of council. All present commissions, boards, officers, employees of the city shall continue in office subject to the provisions of this charter, including but not limited to the provisions governing election and removal and the authority conferred on the city manager and the council of this charter. Okay, to a brief try to take that out of legalese. What they're saying here is they're reserving the rights that have already been exercised. The city's already made a bunch of ordinances, they've made a bunch of taxes, they've penalized people, they've fined people, I don't know that anybody's forfeited anything lately, but Aaron would have to answer that one. But in any case, it doesn't happen very often. All other rights, claims, and demands. What they're saying is what we're doing here with this charter, if we make any changes, it's not going to change the fundamental way of the way the city sits right now. If you took a picture right now of who owed what to the city, who was violating the law, who wasn't violating the law, no matter what we do with this charter, all that's going to stay in place. And changing something in the charter is not going to change the current status of things. And I'm certainly willing to try to rewrite this in more understandable terms, but it's liable to get pretty long and basic. I mean, I like to write like Hemingway, very short sentences, very understandable terms, but this looks like a Faulkner fan wrote it, which I can appreciate, but it's not, just because though it's not the way I would write it doesn't necessarily mean it ought to be redone. It's fairly boilerplate language. This is not,
Rob,
not something dreamed up. Yes, Mr. Hunt.
Yeah, if I could ask you and Aaron to just clarify for a non-lawyer in the group, if we make a change to the charter and this new revision puts some existing city regulations or ordinances in conflict with those new charter provisions, is the city bound to change those ordinances and regulations to become consistent with the new charter?
The city, Aaron, you can correct me if I'm wrong, but the council is at that point has a duty to amend any ordinances to make them consistent with the charter. But it doesn't change the ordinance. That's what this paragraph says. We're not changing the ordinance, but we may put a duty on the council to make some changes.
Are there any requirements in terms of the timeliness of when council has to address those issues, or any other restraints that would make them bring those ordinances in compliance with the charter in a timely manner?
From a practical sense, they ought to do it before they get sued. Or somebody says this ordinance isn't any good, you're trying to enforce it, and it violates the charter. That's a fair statement, Aaron? Okay.
At this point, then, I would ask that we discuss that at a future date as a debatable topic.
What part of that?
That there be provisions on the council to modify, to bring any existing ordinances that are in conflict with the charter into compliance within some type of reasonable time frame. And we may even wind up using that language. I don't know.
Okay. I believe there probably is some language in the charter here, and I'd have to go look for it, but I would hope there's some language in here that states that council needs to amend any laws or any ordinances not consistent with this charter. But if it's not in there, it ought to be. But I'm pretty sure council members are all well aware that they need to make the ordinances consistent with the charter, because they do it quite often. We find things that aren't consistent with the charter, and but you're right. I'd like to see some sort of a time limit. There are certain things that I pointed out that were not consistent. Well, they might have been consistent with the charter, but they weren't consistent with the Constitution. And I pointed them out 4 years ago and was told they were being rewritten, and they still haven't been. So, in fact, did you know that there's actually an ordinance that says that the fire marshal can walk into your house without a warrant in Lago Vista, which I pointed out was a bit problematic, but it's still there. So, there may need to be a review of the ordinances, but I don't know that that's on us. I think that's on council. At least in my mind. Frank, do you agree with that?
Yes. Yeah.
Okay. Aaron, do you agree with that as well? I don't know that we can, it's one of those things, Gage, where even if we say it, we don't have any authority to make them do it. So the authority for making somebody,
I'm not sure I'm sorry, I interrupted, Rob.
Yeah, the authority to make them do it would actually lie with the courts if somebody is aggrieved by some ordinance that is afoul of the charter.
Well, let me ask this question. It may satisfy the whole issue from my standpoint. Is there any similar requirement on timeliness for them to be in compliance with state law?
No.
None that I know of. Aaron?
So the state law sets specific timeframes for when it's effective, and it, unless there's some exception, the state law will govern. So the state law is always going to trump what we've adopted. I believe, Mr. Hunt, section 3.15, speaking about ordinances in general, that second paragraph, if there's a place where you want to make a proposed change, that second paragraph might be the place where you'd add a timeliness aspect to it. It does require that an ordinance must be enacted whenever the purpose is to regulate persons, property, or both, whenever there is an imposed fine, penalty, forfeiture, or tax, whenever the purpose is to set a rate to be paid, whenever an ordinance is required by state law or this charter, or when an ordinance is amended. So that language, it doesn't give a specific deadline, but it gives the affirmative requirement to do it. So that may be something you want to think about.
And it is as firm a requirement as the requirement to be compliant with state law. So I'm okay with that.
Okay. All righty. Let's see. I'm just going to leave this one to come back to, because I read it and I'm not sure I could wordsmith it any more coherently than it already is. But I'm just going to leave that one, and we'll take it up later. But okay, 2.06, 3.01. And this is something that just crossed my mind. This one was mine. I'll own up to it. But currently, we elect the mayor along with the positions 1, 3, and 5, which are in non-presidential years and essentially not the big elections. Is there any support for changing that so the mayor is elected by the most people as possible, which would be, when the big turnout is, which is the government, which is the even years? Ms. Lucero? That's a support for something like that.
Entertain that.
Yeah. Anybody else think that's the way it ought to be? Paul, you think that's the way it ought to be? Okay.
Let me be clear. I think it warrants further discussion on the.
Fair enough. Yeah.
Next item.
Fair enough. Mr. Tannehill, you got any thoughts on that?
I agree with you.
Okay. All right. Then I will leave that comment in there. Okay. The next paragraph was I highlighted it in here, not just on our sheet, but terms of office are now 2 years. There was a mention of the potential of changing that to 3 years. Does that have any support? That's got a thumbs down from Roberts, Lucero, Hunt. I'm not really in favor of that either. I don't know that there's any. Mr. Tannehill, do you want to weigh in on that?
Well, I don't know. If you're doing odd and even numbers as far as voting years, 2 years would make more sense. Stay 2 years.
Well, yeah. I mean, we'd have to go to a completely different voting schedule if we went to 3 years. Plus, as Aaron pointed out, there are some changes the Constitution would require if we change that to 3 years. There doesn't seem to be a lot of support for that, but I will leave it on there just as.
I withdraw the idea.
You withdraw the idea. Okay.
Yes. That would make it simple.
It does. Okay. And then I've had several people contact me and ask about term limits. Mr. Robbins wants to give as much flexibility to the council as possible in most of this stuff, and I'm kind of the mind I like the people to have the most flexibility as possible, and I just think that might be a self-correcting thing, but it's been brought up, and I don't want to poo-poo it just because of the way I'm thinking. I'm sure there's folks here that suggested it. So, any additional thoughts?
Just keep it on the table for later debate.
Okay. All right.
I know you all discussed at large and by place last time.
No, we didn't discuss it last time, but we're going to this time.
Okay, perfect.
we are going to this time when we get down here to that section, which I think is down in the election section. So
okay,
it'll take us a little bit to get to that. That's on tonight's juicy hit list. Oh no, it's not. It's right here. No. Oh yes. Wait a minute. Sorry. Actually, I think it is time to talk about it right now, and that is there was a suggestion that since we have places 1 through 6, should those remain at large, or should those reflect actual geographical locations?
I'm okay leaving that up for future discussion, but
yeah, my thought is at some point you may have different at large pieces and things, but I'm not sure how all the different areas are going to grow and not grow, and you'll be changing your charter often. I think if you get into that at some point, a quasi deal where you got some at large and others, but I don't know. We got a lot of stuff to tackle.
I think I personally would not support that. I would oppose that.
Okay.
I would oppose that as well. I
Okay.
like that.
Yeah, I would oppose also. I'm just not aware of any communities that are our size that have geographic districts.
I think it'd be a nightmare to figure out.
Just right now, then. But who wants it up for further discussion?
It was Councilman Davila. I think this was your suggestion. Do you want to weigh in here?
Mr. Durbin, I would be happy to share my thoughts when you get to actually discussing.
Debate time?
Yes.
Okay. All right. We'll leave it on the placemat then.
Frank, you were shaking your head. I'm sorry to interrupt, Mr. Durbin. Frank, what's your thoughts on at large versus place?
Yeah, I saw a thumbs up, Frank, but I didn't know whether your thumbs up was agreeing with the other folks or if it was a thumbs up on the idea.
I'm agreeing with the other folks.
Okay.
And I'm also agreeing later.
Okay. Good. Yeah, I agree. Okay. All right. But we'll leave it on there and discuss, and we'll give when the appropriate time, we'll give Councilman Davila an opportunity to present his arguments on that. Okay. Now, all right. 3.03. Let's see. Mr. Roberts, I think you were the one that originally caught that, but I've had a couple other folks catch it as well since we talked about it.
What's the item number on?
It's actually not on. It was on your thing, and I made the change directly into the document.
Okay, I've got 3 documents in front of me. I'm just trying to find the right one here.
Okay, it should be. It's 3.03 of your version. Of mine today. Yeah. basically it's no member of council. I added to try and satisfy what we were all talking about last week. No member of council will act as judge of the election in dispute in which that member is or was running as a candidate, and will be subject to automatic recusal of any dispute involving that member.
Personally, I think it's kind of a no-brainer.
Okay. All right.
Mr.
Robbins? Mr. Robbins?
Yeah, I think simply thinking about this, if somebody is run for election and somehow there's a dispute about that person being elected or not, then that person ought not to be involved in determining the fate. I think that makes sense. My question and it's a question.
Okay.
Who determines, and what's an example of an individual place's dispute? Who could decide that there is a dispute?
Well, at the moment, this paragraph says the council does. The council's the judge of the election, and the qualification of its members and all officers and officials of the city appointed by council.
That's not a disputed election.
Okay, well, that's true. This is basically the judge of who decides who is qualified to run or be appointed.
Yeah, and I don't.
You maybe.
Could all of the incumbents be in dispute?
Yeah, at some point, that's possible.
And I think that's a more likely issue related to election disputes than an individual place. So
to rectify that, then at some point there would need to be a judge of election qualifications named.
Well, with staggered terms, there's no way that all all incumbents could be in dispute, right?
Yeah,
you would only have 3 council members and the mayor left to make the decision. But
yeah, I said all incumbents, but I don't know how the process would work. How would one determine if a dispute disqualifies a council member from determining or being involved in that process? Who determines that a dispute?
Well, maybe it shouldn't be limited to dispute. Maybe it should be any action involving that particular race.
Well, and keep in mind, this section is just addressing election qualifications, which are listed right above this in 3.02. So really, the judge of who meets those qualifications currently is the council. Now, and who can raise a dispute, I think is what Frank is saying.
And Ms. Durbin, okay. I agree it's in the wrong place because it's just qualifications, but.
Right. I think it's talking more about the judge of the judging an election dispute.
That's correct. I understand where Frank's coming from.
Yeah. Okay. So this section may need to be just, well, let's see if it's taken care of when we get to the right place, because this ain't it. So, are we agreed on that?
The other issue, Mr. Chairman,
yes,
is if all of those who are part of the election, if all the incumbents in theory rerun for their seat, and if their seats are all involved on a year when the mayor's seat is up for election as well, you may not have a quorum of the council to make a decision about it. So you put, unless only that particular seat you know, that person is removed from the discussion and all the rest get to decide about that one, and then vice versa, you know,
Well,
because
I hear what you're saying, and here's the thing that I see, and it's you know, I don't want to give anybody like crazy ideas out there, but if somebody was to say all of a sudden that, you know, that an elected official all of a sudden doesn't meet section B, which is something I actually wanted to talk about anyway, be a registered voter residing in the city.
Oh, 20 minutes.
Is a registered voter an antiquated term, by the way? But because you can just show up with your ID, you don't necessarily have to be a registered voter, I don't think. And but for instance, somebody says none of the council is a registered voter. I don't know, how does the debate start? Does a citizen file a formal sworn complaint? Does you know, there's no real procedure for that in here. But in any case, if somebody does that, and I'm not sure the council is the right folks to be deciding that anyway, but I don't know who else would do it unless you gave the job to the municipal judge.
so the other problem you have, and maybe I'm reading this a little differently than the rest of the committee, but the Texas Election Code section 32.052 states that a person who holds an elective office is ineligible to serve as an election judge or clerk in any election. So
yeah, this whole section might violate state law.
Right. I think that's more the issue. It also says a person is ineligible to serve as an election judge or clerk in a city election if the person is a candidate for a contested public or party office in an election to be held on the same day, employed by an opposed candidate in the election. There's a list of campaign treasurer, finally convicted of an offense. There's a list. So I think that section as a whole needs to be reviewed if what the intent of this section is an election judge or clerk under as the election code lays it out. If it's meant to do something else, then.
But if the election code lays it out, I think those people are the ones that have to review the qualifications and make sure they were eligible to run in the first place. Am I not right?
Right. And so typically, if you're looking for who's qualified to run, typically the city secretary reviews the applications to verify whether they meet the qualifications. After her review, it goes to the city attorney, and I would look to see whether I concur with her analysis and then prepare the documents to let that candidate know if they're ineligible and what the basis for their ineligibility is. So it's not actually done by the council itself anyway, as far as determining who qualifies to run.
Right. The question is, at the time there's a challenge to whatever you and Sandra would decide for if somebody just comes up with it, but I don't know how that procedure would start, and it's probably not laid out anywhere, but
it's in the election code, Mr. Chairman. Election code 143.006 says that a candidate's applications file with the city secretary, but a home rule city may designate some other authority by charter or ordinance adopted under such charter authorization. So that's where I think that this is coming from. On the acceptance of applications for filing by an employee of the designated authority, it can be by other people that are designated. But if you look further down, the election judge, which is serve somewhat of a different function, not looking at qualifications, but looking at whether the eligibility of the candidates. So I think we just need to dial in on what exactly your understanding of the intent of that section is. If it's about the qualifications of the candidates,
I don't
then
know what the intent of this thing is, but I think I think it would be wise to shield council from anything having to do with the election if we can. Does that make sense to everybody? Yeah.
I like the idea of the qualification being submitted to the city secretary and then double checked by the city attorney, something like that. But I think having it in the council's hands is a little too much.
Well, and this kind of seems to say that the council could come in after you, Aaron, and just say, yeah, nope, that guy's in arrears to the city. We declare it. So, you know, I think this is an area where we can help the council out by shielding them, by getting them out of this process. I didn't think about that before, but after Aaron's reading of the law and us sticking in some verbiage in the wrong spot, I think we may want to take a second look at this and see if we can find somebody else to do that, or specifically name exactly how the process is currently working to determine qualifications. And once the city secretary says it's a go, and Aaron, I think she can come to you as a city employee for counsel on that, on any questions, rather than put you into the loop. I think it's best to just leave it, to maybe possibly change that to be, you know, the city secretary shall be the judge of the, see, and wording is odd here. So is the judge of the election and the qualifications of its members. She's not the election judge. Is judge of the election the same thing as the election judge? Okay, I'm going to put a note here so we can move on. I'm going to highlight it and put a comment out to the side that says, at the moment, this paragraph is screwed up. Because that appears to be the consensus.
Maybe something like the city secretary will check the qualifications.
Yeah, this one I think just will require some more thought, and but let's all keep in mind as to whether this section, the second part is when we get to the actual election judge is in there, but that may be more of a function of state law as to how the election judge determines, and the council I don't think has anything to do with that.
Well, so state,
other than naming the judge.
Right, state law says if the city council appoints election judges for city elections, that's all in the election code 32005A. So that's, you know,
Right.
they appoint the people who are the election judges.
Right, I'm racking my brain trying to think out if there's any other place in here where they appoint an election judge, or is this it? Because it says the council shall be the judge of the election and the qualification. Hopefully that's not it.
It should say something like they appoint
Yep.
the election judge.
Agreed, but let's see if we can find it.
I wonder if the original intent wasn't to just be a reference to the canvassing of the elections.
No, because there's a whole section on canvassing later.
Oh, all right.
Yeah, I'm not sure what the original intent was, but I think we got to come back to that one. And it's, since we just discovered the screw up, let's all think about it. 3.05 compensation. Compensation for the city. It's not a well-written paragraph, and I tried to add some clarification language, and basically I think it's the council that should determine whether there should be a compensation package. And but Paul, you brought up a really good point. No sitting member should be able to declare a compensation package for themselves that term.
Yep.
So if they do enact a compensation package, it can't be effective until 2 elections later because of our staggered our staggered elections. Does that make sense to everybody? And if so, what I wrote, does it look viable? And you have plenty of opportunity to look at it later and tell me if you don't think so. But that's what I was going for when I heard this, because and I mean but I think the council should determine the compensation package because they have more flexibility. You know, we're growing like crazy and we can't ever foresee it, the city shrinking. But being an oil and gas lawyer, I practiced in a lot of little towns that never thought they could shrink, that are nothing more than wide spots in the road now. So, you know, I think we should leave that as flexible as possible. And in that case, that leaves it with council. Does anybody think we ought to mandate it in here? Plus, we don't know what the budget's going to be every year or what the city can afford. So I don't see how we could address it.
Well, is there anything in our ordinances that addresses this?
But this leaves a provision so that they can, if there isn't. At the moment, I think the ordinances say they will serve without pay.
I think this gives the council, kind of like one of the first topic of conversation, I think it does give giving the council leeway to legislate as they see fit. It's important.
Yeah, to a certain extent, when they don't need the training wheels. Yeah. But you know, the council are citizens too. They're not pros from Dover. So
the question at hand is, should we leave this on here for addressing? Correct?
Yeah,
not figure out the language right now, but should we leave it on here to address?
Yes. Yeah, I'm not going to take it off. It's something. This is one that's big enough, and I've heard enough about. We ought to vote on it. But that's okay. Frank, did you have your hand up?
Yeah, it's a quick technical question. If you say it's not going to be effective for 2 years, that's okay. But the council is still going to have to act on that separately in the budget. So if the council votes in 1 year to compensate council members 2 years hence, because that's what this will do, at least 2 years,
right?
Or 2 elections, whatever that time frame is.
That's 2 years.
Still going to have to act on that compensation package as part of the budget the year prior to its taking effect. That's just a technical point.
That's true, but they'll have an ordinance that hopefully says, you know, we're going to pay, council will pay itself X number of dollars per year, and then, you know, that gets jammed into the budget. But I don't know that the budget committee wouldn't have any authority to change that ordinance. And I think
no, that's not my point.
What
this year, if the council says we're going to compensate ourselves in 2023,
sure,
okay, because if that's the charter change,
yeah,
for 22-23 budget year, the council has the option not to do it.
That's true.
Okay, that's all.
That's true. Yeah, I mean, we're not going to force them to do anything.
If they decide not to do it and they don't put it in the budget, it doesn't happen. Okay.
There you go. There you go. How's that for lots of flexibility? They can twist themselves in knots all they want, but this lets them do it if they want to. But I just don't think it's fair to have them. And I heard a lot of folks say, if you do that, make sure that they can't vote themselves a pay package starting right now. And I think everybody's in agreement on that. Yes. Okay. Okay. 3.06 compensation. Man, this may go long tonight. I hope you all had a big dinner. But 3.06, the mayor. In reading through this and in reading through the charter, and I had flagged it last time, but I didn't address it very well when I was explaining it. But it appears there are parts of the charter that says, the mayor has some additional duties in times of a disaster, and in other times they have, they're the ceremonial head of the city. But other than that, they're pretty much just a counselor, just like the other 6 guys, even though he runs the meetings. And it seems to me, if that's the case, then F is in conflict with I think it's 3.23, where the council members are not supposed to address any city employee unless it's as a collective body. No member of council shall give orders directly to the city manager. And I know advice is not an order, but I know council is also trying to prohibit councilmen from consulting and giving advice, because when it comes from a councilor, or especially when it comes from a mayor, it can be perceived as an order or a directive. I just think that the two things are in conflict. And Frank, I know you've got strong thoughts on people chatting with council members, speaking directly with city folks, city staff. Go ahead.
Well, no, I didn't want to interrupt you.
I was done.
Yeah, my issue's with the staff, but not the manager. I think the manager needs to be able to listen to however council members individually want to speak to him.
Okay.
And it seem like orders.
So should this provision also be extended to council members? That they
well,
may
no,
consult and
the
advise the
council
city
can
manager.
go in and visit with the manager. That's not a charter violation. And they have to be able to do that. The manager has got to be able to listen to his people individually or collectively, or a couple of them at one time. He's got to be able to do that. And if they come in and say, look, Mr. Manager, I think it would be really important for us to look into how we're doing water rates. I think they've got to be able to do that. And the manager's got to be able to handle that. 2, that's A. B, that's the issue of communicating with the mayor and other council members, having the ability to communicate with the manager. And it's going to, if you're in those meetings, it's sometimes going to feel like an order. And the manager can look right back at them and say, boys, I'm not doing that. Now, if you want the council to discuss it, that's fine. But I'm not doing that. That's part of what managers get paid for. The other point that I would make about this section that you brought up is that I would hope that the mayor has at least the same authority as a committee chair or a board chair, which means that they get to act on what the agenda is going to be. You with me, Mr. Chairman?
No.
If the mayor wants to put something on the agenda, he gets it. I think he ought to be able to do that, period, in the message. He goes in, says to the manager, however the process is to get stuff on the agenda, he wants to add something, he can, because the board and commission chairman can do that.
Sure.
Okay. And so wouldn't take that away from him. The problem is too much detail. The problem I have with
you're talking about
stuff that's happening currently is that the mayor, and we've lost the city attorney. No, where is he? He's still here. What has happened when I was on the council is that during a meeting, the mayor would say this item is pulled. I don't think he can do that. So, and this is what we talked about at the last meeting. So I think the mayor ought to be able, unlike the rest of the council members who have to have at least 2 of them, I think the mayor ought to be able to put stuff on the agenda. But when that agenda gets to the 72-hour point, it can't be changed by anybody until you go to the meeting. And so we've had instances which the mayor pulls stuff at the meeting. I don't think he can do that. Okay.
Yeah, well, okay. All right. Well, that's section G. Now on F, okay. Everybody thinks that the mayor ought to be able to sit down, talk, have any sort of a frank discussion with the city manager, and that's fine. Frank, you also believe council members should be able to do that as well, correct?
Yes.
Okay.
I agree with Frank on that point.
I do too. I do too, and I'm not arguing with you, but it's been a little odd lately. If that's the case, then I think that the same provision should be extended to city council members when we talk about their authority. It ought to be stated. Okay, but we'll get to that later. That's a different paragraph. And then the second one under G, may require any item or items to be included on or deleted from the agenda. Okay, so Frank, let me see if I understand you right. You're saying the mayor may require any items or items to be included or deleted from the agenda prior to publishing or prior to 72 hours. Can he amend it once it's been published without giving any notice as to why?
Yeah, here's what happens. Here's what's happened, and Aaron's going to have to jump in and correct me, or Arch or somebody. In terms of agenda preparation, it gets published, okay, and then after that, it gets amended.
Right.
And I think that the mayor wants to add something, for instance, or delete after it's posted, that he should be able to do that. Okay?
Okay.
Because I think I'm a little uneasy about it, but board and commission chairs can do that, except in certain situations in which you've given notice, et cetera, and they can't take stuff off that you've made notice about. I'm getting into too much detail. For instance, could the mayor pull an agenda item for which notice of a public hearing has been made? Aaron, can he do that?
There's not anything in the law that says he can't.
Okay.
And the charter says he can, or it's not specific. It does say that the items can be deleted. It doesn't give the deadline. It doesn't say before publishing.
Right. And so that's my point, Rob, as I try to get through this. The point I'm making then is there's a deadline in which state law says you can't change your agenda. That's 72 hours, correct?
No, I think the state law says you can't add anything to it after 72 hours, but you could probably delete. Am I right, Aaron?
Is that correct?
That's correct. Yeah, so what the state law says is you cannot consider something unless notice of that item has been given a minimum of 72 hours prior. It is silent as to whether or not you can remove something or choose not to consider something even though notice has been given.
Okay, so my point earlier that I don't think the mayor should be able to pull an item at a council meeting, he can. Correct? And he's done it. And he's done it.
But
the question is,
he can't do it if two council members want the item on the agenda. Correct?
That's right.
So he can pull it. Well, no, but that's not, I don't think that's correct, because if he can pull it, they can't add it back on without giving 72 hours notice.
But he can't pull it. It says in the existing language, agenda items which have been specifically requested by two or more council members may not be deleted.
Gage is right. What I've seen happen, though, is where two council members don't want something on the agenda and it's been removed from the agenda, and that's wrong.
That's correct.
Yeah, that's wrong. That shouldn't happen. But and the way I read this, and here we go, we might have a different reading of the same lingo again, but the way I was reading that is, if the mayor puts an item on, if he can delete any item on the agenda except those that were requested by two or more councils, because two or more council members can request an agenda item, at any time, back before the 72-hour notice or anything. But I don't think this gives two council members the power to say, oh no, you can't, Mayor, you can't delete it, because it specifically says he can add it or delete it. But if that item made its way to the agenda in the first place by two council members requesting it be on there, then I don't think he can delete it.
Oh.
But
you're saying they never could get it on the agenda to begin with?
No, two guys can get it on the agenda.
Okay, well then it says that it can't be deleted from the agenda if two or more council members.
Right. If two people
submitted it.
If two council members put it on the agenda, it can't be deleted by the mayor at all, ever, anytime. Is that correct, Aaron?
Right.
Okay. But I think what they're trying to say is, if the mayor, in exercising his power to strike something from the agenda, let's say it's something the mayor put on the agenda, and you go into the council meeting, he says, I want to strike that from the agenda. I don't know that two members at that point could say, oh no, wait a minute, that's got to stay on there, because they weren't the ones that initially requested it be on the agenda.
It's like they don't have veto power.
Correct.
Essentially.
Correct. So basically this says if the mayor wants it off, he can get it off, unless it got there by two members putting it on.
Rob, I'm okay with what you wrote.
You're okay with what I wrote?
Yes, sir. Just got to check.
Okay. In the event an agenda is deleted by the mayor, it shall be noted at council that was so deleted and why. That it was deleted. Okay. Sorry, I was cranking that out pretty quick. That it was deleted and why. I think that's, and then if we do that and the mayor and two council members say, oh, no, wait a minute, they can put it back on the agenda 2 weeks from then. The exact same thing, correct? So and the mayor may have a real good reason, but if two council members think he overstepped, they can put it on the agenda at the next meeting. That's the simple solution.
Yeah, let me give you an
And we don't
example.
have to write that in. But yeah, go ahead. Go ahead, Frank.
Here's an example of the problem I have, but I mean, you got a really difficult zoning case and the council member's full of folks and the mayor doesn't want to have the fight that night. So he says, you know, folks, he's got 40 folks in the council chambers. We're not going to do this tonight. He can do that. And I just think that's wrong.
I agree.
I agree with that too. It's hard to get those 40 people to come back in 2 weeks.
They're going to be unhappy folks at that meeting, I guess.
Well, you're either going to have no folks at the next meeting, or you're going to have 150 folks and have to cancel the next meeting and move it to the barcade. So
yeah, how do you fix that? I don't know.
The only way I can see to fix it is to put a hard and fast 72-hour limit in there. But let's leave it to talk about on another day, rather than disagree on that one. It's one of those that we can just do better on if we think about it. Okay, I've had several people ask, do we want to define declared emergency? And we had some chat about a defined terms section, and there was arguments on both sides. Do we want to just do we want to start having a defined terms section that we may talk about later that includes declared emergency and any other phrases we come across while we're going through this? I got a thumbs up from Christina. Thumbs up from Frank. All right. Let's see. Let's do that then. Okay.
Is there a concern that the mayor is going to declare an emergency outside of Chapter 418 of the government code? Because that's where his authority comes from.
I think that's Rob's point, right?
Well, I don't know. I mean yeah. If that's where it comes from, then that's where it ought to point to.
Which is, yeah, just reference it.
Yeah. What was that section again? And I'll go ahead and stick it in my comments here so we know.
It's Chapter 418 of the Texas Government Code.
Okay. All right. Let's get on down here. The section on, and I think this is just something we need to discuss later, whether it needs to be failure to attend 3 consecutive council meetings or 3 consecutive regularly scheduled council meetings. I think we just need to leave that on there and come back to it when it comes debate time. I'll tell you my objection to just saying 3 consecutive council meetings is, we have people that are council members that actually still have daytime jobs. And unless we want to have council members that are free at all times, I think that section could get abused pretty bad. So it hasn't been, I don't think, luckily, but it easily could be. But anyway, we can address that one later. And on advice in our consultation with Aaron last time, I changed in the next paragraph executive session to open session in the next 2 paragraphs because I don't think that, we didn't think that any of that discussion qualified to be an executive session. And we're still of that mind, Frank?
No. Why isn't that personnel action? It could be discussed in exec.
You're muted, Aaron. There you go.
Technically, council members are not considered personnel
Yeah.
under the law.
I don't think appointees are either, are they? Appointees, council members, I don't think any of those folks are.
Yeah, just like the city wouldn't be able to defend you either. You're your own person.
But that's a little bit different because there's some very distinct nuances to that, but you're not employed by the city.
Okay,
The council members are not employed.
You can't do it in exec.
Well, I don't. I
When
personally don't.
when does the council member get to defend?
He defends an open session.
When? All this section talks about is reading the allegation in open meeting.
Okay, well, I didn't change the procedure at all. I just changed where it gets heard. Let's see. The first time it's read in open session to determine if it alleges a complaint. If a majority finds that the complaint alleges a violation that is grounds for removal, it shall set a time and date for a hearing in open session on the complaint. That's the hearing at which the defendant can, or the respondent can present a defense during that hearing in open session.
That's a one-sided deal, Rob. You know that.
Why is that? What? I think it's more one-sided in executive session.
You get a complaint and the council says, yeah, that's a good complaint, regardless of any facts that may have been presented.
No.
And one party can't present facts. Only one party's facts are going to get presented.
Hang on.
As opposed to a defense.
Hang on. The first time it's presented in open session, it's presented solely for the purpose of determining whether it states grounds, not whether there's any merit to them. It's just whether it states grounds. It's like reading a pleading at the beginning of a lawsuit.
Got it. Thanks.
You know, I mean,
I got it.
Okay.
I hear you.
Okay. And it should be limited to that.
Right.
Now you know how, you know what, some poor defendant who has the state reading the complaint at the beginning of the lawsuit. And they've got a presumption of innocence, but so but that's the procedure that's laid out. I didn't want to change that. I just was trying to, I just didn't think it qualified for executive session. Okay. Are we all in agreement on that at this point? Or I'll leave it in there, and it can be at some point, I'd like to kind of bundle some of these up that we all agree on to the best I can, and kind of move them through on like almost like a consent agenda to either approve them or get rid of them, one of the two, and then get down to brass tacks and debate the ones that we really have an issue with. Okay, in 3.9, filling of vacancies, the chairperson, there needs to be an order. And you know, I don't know whether the chairman of planning and zoning or the chairman of board of adjustment or whatever, you know, the grand poobah of whatever should be the first one up. But and it doesn't really bother me which one is the most important from a, I would think from a governmental and legal standpoint that it would be the chairman of the BOA, because that's a decision, an arbiter, a decision-making board, and not an advisory committee. And it's the only one mentioned in the government code, for that matter. Frank?
Yeah,
Oh, that's a thumb. Oh,
I
okay.
agree on both points.
Okay. All right. But we can put that order together at a later date. That's okay. I want to get down here. On the rules of procedure, ordinance for procedures conducting council meetings, and we're currently doing it. We're making the minutes available to the citizens via the city website, rather than, since that's what we're doing, it didn't seem to make sense to leave that for reproduction fee in there. And I think that was espoused by somebody other than me that caught that, but I think it's a good idea. Anybody else have a problem with that one? Nope. Okay. Hey, Carter.
So let me, quick question.
Yeah.
Does that mean that a citizen can't ask for hard copy? Or he can't get a hard copy? I mean, asking is one thing. Does that mean they can't get a hard copy?
Well, I think it's a city document. I think there's something in here already that says they can get any document made from the city via and possibly have to pay a reproduction fee if they have to do that. I don't know why anybody would do that, not just print it off themselves, but I think that's in here, but we can double check that when we get to it. Nice to see your face, Carter.
Yeah, I figured out what all these buttons are for.
There you go. Let's see. Aaron, since you read it earlier, where it says an ordinance must be enacted for the purpose to regulate persons, comma, property, or both, is that a change that you liked as well, rather than it's used to say persons and property? Did that get a thumbs up from you? You're muted.
Just when I muted myself. I think it's an appropriate adjustment.
Okay, good. All right. Frank, this one was yours, 316. I took a shot at trying to get where you were trying to go, and descriptive captions seem to be the most available pair of words to get some understanding of what the ordinance was going to say.
Yeah, I think what happened, there we go. And I'm going to have to refer to my notes elsewhere, but my personal feeling is that they could read the caption or the title. Let them do either one. I don't like reading the caption because it's too long, but that's one you can choose to do. Is that correct, Aaron, or have you told them they have to read the caption? You're muted.
I would prefer that they read the caption. I'm looking at what chapter 53 says. Hang on one second.
Yeah, because we just used to, in most cities that I've worked for, they're reading the title. They're not reading the whole caption. Some of which go forever.
So one interesting thing, and I'm sorry to backtrack, but I should have brought this up about 30 seconds ago. Printed copy as an evidence. A municipality shall have printed under the direction of governing body a copy of the code that is authenticated and approved by the mayor's signature. So that's one of the things. So we are required by law to have a printed copy.
Are we
If you
there?
don't want to pay for it, that's a different thing. Adoption, it's not 53.
Yeah, my issue is that there's a discrepancy in this section about whether it says title or caption, which is in the second sentence. Further in 316, it says shall be considered, and the description caption of such ordinance read. So it says in one place either or, and later it says caption. So do one or the other. And if the state law says you have to read the caption, then say that and delete title.
Which that's what I thought we had figured out last time. So that's what I did. Crap, what did I do? Oh, there we go. Aaron, are you looking something up?
Yes.
Okay, you want me to go on and come back to you? Okay. All right, we have a potential new paragraph of things that would require a supermajority. And we talked about that. And one of the issues was the compensation for the city manager, and there's a few other things that require a supermajority, and do we want to protect those supermajorities in the charter? I think Mr. Roberts, I think you were in favor of protecting them. Mr. Robbins is not. So,
Yeah, here's why. Because some of that stuff's state law stuff. Supermajority is required by state law issues, and again, it's the flexibility of the council. So I don't think you have to list them in the charter.
Well,
I'm not saying you have. I'm not saying you do have to list them, Frank. I think the question is are some of those things sacrosanct to some of the citizens, that to the point where they want to protect that supermajority so it doesn't get changed? If I'm not, and I don't want to make their arguments because this is not one I've got a big dog in that fight. Mr. Roberts, I think, did I express your argument well or not?
No, you did fine, but I mean, I also concede Frank's point, and especially with Aaron's nodding endorsement. And you know, it's there. The state law trumps. So,
what are the provisions of state law requiring supermajority?
Hang on a second. One of because I think there's a misunderstanding here. State law trumps when it gets to a point that says, you know, you can't do this. But there's nothing in state law that says you cannot, that a charter can't also limit this stuff. A city can limit itself as much as it wants. So, you know, that, and I'm sorry, I might have misunderstood you, Paul, but my impression, I think, is from.
I'm trying to find your notes real quick. I'm jumping between three documents.
Because what I'm thinking, well, I don't have the new paragraph up there. This is just a kind of a topic for discussion. But you know, and I think one of your arguments in the past has been, you know, we have a comprehensive plan, and that comprehensive plan, it should not be etched in stone, but it should be etched in
a supermajority
sandstone. Yeah, so that it takes that it just, you know, why spend all the money on a comprehensive plan if you're not going to pay any attention to it? And
It's not so much as it's about money as it is certainty and a plan. You have a plan, you stick to the plan unless a supermajority wish to deviate from that and there are findings of fact made. My only concern when it comes to things like this is you get into a situation where while an ordinance prescribes for what those findings of fact must be and that there must be a supermajority, you know, there is indeed, the way charters are written so broadly, you know, there's still room for mumbo jumbo lawyering to go on, and people can still deviate from it, you know, even without accurately finding those facts.
So rather than change the law that requires a supermajority, they can change the law regarding what facts need to be found and stuff like that.
Or they could just manufacture BS facts and say, well, those are our facts, you know, and then, you know, even though they weren't based in fact, and you get to litigate that. And it makes it onerous.
As a litigator, I'm all for that sort of ambiguity.
But the point is, it's enumerated in a city. In this instance, it's those findings and reasons and cause for deviation from our governing documents are there for a reason. They're explicit, they're black and white. But in practice, they're ignored, or they can be ignored, and there's really nothing you can do about it except sue the city.
Okay. Yeah. And Frank.
Rob's talking about a particular provision in the zoning ordinance, or Paul is.
Yeah.
That's not charter requirements for supermajority. It's a problem with the zoning, and particularly the ordinance and how it's used. Let me just state quickly, and I am very strongly opposed to the idea that the council can't change the charter by majority vote, and it requires the supermajority to change the comp plan. And Paul and I have had these conversations. Our charter, and it's been studied, and the list is out there of what's wrong with our current charter. There's a bunch of stuff wrong with it. And to require all of that to be done by supermajority is not a good thing.
I don't know what you're talking about, Frank. I mean,
there was a study done 2 years ago, 2+ of the current charter. And a report was made to the council, and the council agreed that here's some problems with the current charter. The biggest problem with the current charter is the land use map, not at what Paul is. And I could go through a long list of the problems with the land use map and other policy statements, most of which can be found in all of which can be found in section 9 of the city charter. And so that group, the recommendation, and the council agreed, was to review those policies, the map, the land use map, and the policies. The point is there's a bunch of problems with the current comp plan, and I don't think the council has to have a supermajority to change it any more than they had to have a supermajority to adopt it.
Maybe I'm confused, because I don't think the land use plan is in the charter at all.
It's not. You're talking about the comp plan.
But Frank.
All I was doing was trying to come up with an example of a supermajority that may not be in state law that we may want to keep or not allow the council to willy-nilly change it.
Well, I'm opposed to that's not willy-nilly the majority rule. That's my point. I'm debating Mr. Chairman, your point that you might want to have a supermajority to amend the comp plan. I don't agree with that.
Oh, okay.
Well, it sounds like that needs to be on the debate list.
Yeah,
Yeah,
let's
no
put that on the
kidding.
debate list in the interest of
Yeah, I'm gonna let, and all I did was remember something, remember an argument Paul made once that made sense to me. That's all that's going on here. Okay.
Mr. Chairman,
Yeah.
before we get too far afield, we just wanted to touch base. I was looking up something.
Yeah.
So the reason I recommend that the caption be read is state law 50, local government code 52013 regarding home rule municipalities says the governing body may publish a caption of an adopted ordinance that summarizes. It allows you to publish a caption. It would never allow you to publish the title in lieu of the full text of the ordinance itself. Okay. And that's the part of the basis why I recommend using caption in that previous section and not title, because the caption, the requirement for the caption is that it summarizes the purpose of the ordinance and any penalty for violating it. So that's why.
Okay. So some of our captions may be long, but using the descriptive caption is probably the best practice.
It's the safest. It gives the public the most information.
And let's
it's
do that.
a little wordy, but
okay.
It makes it very clear what you're adopting.
Okay. All right. Let's see. Now this next one, we're down to 317. Thank you, Aaron. This is where I think we need to keep, and I think we were talking about something else, but I think you mentioned this, that we do, the city does need to keep a printed record of the code of ordinances. And I'm assuming that means it needs to keep, every time it changes, we need to have a new printed book.
Yeah, it's an outdated and outmoded way of dealing with things, considering that we use Municode, but for historical purposes, I think that's what the intent is, so that you have to be able to find a way to track back what your what the prior version was.
Exactly. Okay. Which was the point we made last time. Christina, your hand's up. Yes, ma'am.
I've tried looking for stuff on our ordinances, and it's not the most easily searchable document. I mean, I know that things are entered in by date. I mean, how difficult is it to make something like the charter that is easily searchable?
Well, the Municode when you go to the and I just had I clearly don't know. We're talking about two different things, because Municode, when you go to the website, is searchable by word, and it will pull up everywhere that appears. Now, if you pull up the word, ordinance, it's going to be in there a lot. If you pull up the word, height or building height or something like that, then and you can phrase it out, and you can search that. The problem is you can't go search old ordinances and things like that, and then before it gets codified into Municode, it is kind of difficult to find. But if you go to the link that says Code of Ordinances and get to Municode, its search thing works pretty good. And it's so, and you guys seem to update them pretty fast too, Aaron, into the code. Ordinances seem to make it from ordinance to code, or resolution to code or whatever pretty quickly. So I know the recent ones aren't. And usually I just bug a councilman until they tell me about what month it was, and then go back and look at the minutes. But in the minutes, you can do a search of the on the website, and it will pull up the, you know, wherever a word appears in the minutes as well. But so I'm probably not talking about what you're talking about. Can you tell me what it is you're trying to do, and then let's see if we're on the same page here.
Just since things are entered in by date, you don't always know when something happens. So it's difficult for the common citizen to go in and search for something. I just didn't know if there was an easier way to have that sort of a database that's more easily searchable for the common folk.
Well, for the ordinances as they go until they get codified, date's pretty much it. And I don't know that they, I don't know exactly how searchable that is. But that may be more of a policy thing than a charter thing, because when we talk about a systematic record of all corrections, amendments, and revisions, you know, what we're talking about there is I need to know what the law was on January 15th, 2011, and I can go back and I can pull the 2011 little code book and look in there. Does anybody else, can anybody else address this question better than I'm doing? Because I'm stumbling here.
Maybe.
I realize that.
So the way it's supposed to be done is anytime a section is amended, the reference to that ordinance is supposed to be provided. The ordinance itself is supposed to provide you essentially a red line strikeout version. Anything that's new is supposed to be underlined, and anything that's deleted is supposed to be stricken, so that you can look back when that ordinance was adopted and see what language was changed. The only exception to that is if something is repealed in total and replaced. And so that language is supposed to be in the ordinance explicitly, that this entire section has been repealed and replaced, so that you know what the new language is how it's supposed to read. But you know, most of the time you're gonna do strikeout, underline, and strike through mode for most of your amendments, because you know, you're changing little things here and there. You're updating a fee, or you're, you know, changing a effective when something's due or something like that. But that's how it's supposed to work. That's how I've been doing it. I can't tell you that my predecessors have all been consistent in doing it that way. I've had the challenge of digging back through historical versions of documents, and sometimes, you know, I just have to get it out and compare line by line and to see what's different. And that's not best practices by any means. But, you know, I think, you know, prior councils, or, you know, when someone other than an attorney was preparing the ordinance, you know, and if it didn't get checked by the attorney to make them do it in the underline and strike out method, you know, I'm sure in the city's more infant years, it may have been done a little differently, but that's what you should see. Certainly anything from 2020 on, that's how I advise all our folks. That's what because that's the only way you can see clearly what's being taken out, what's being added. So the backstop to that is to do side-by-side comparisons of the version of the ordinance as it was adopted previously with the current. And that's a long and tedious process, but lots of us get that pleasure.
Yeah, it's the only other way to do it, Christina, would be kind of like the state does. And it's, you know, they've got a couple of different dates a year in which all their legislature becomes effective. Very rarely is something effective right now. It's effective, you know, January 1st or September 1st. And the reason they do that is because that's the day they want to print a new book. And the city doesn't do that because they generally, when they change something, they want it to change wiki. I don't know whether I agree with it or not, but okay. Frank?
Question. Take a look at section, the way it's written now, 3.17.
Yes.
And what does this mean? So the city, this talks about posting. To be published at least one time in the newspaper, general circulation within the city, and posted on the website until such ordinance becomes codified in the city code. The codification is what we find online in Mooney Code today, correct?
That's right. That's correct.
Okay. All right, got it. Thanks.
Yeah.
The provisions of this section shall not apply to the correction, amendment, revision, or codification of ordinances of the city in book or pamphlet form, which we no longer do. Correct?
Well, I think
that was my point.
Well, I think
it's not applicable. That's in it.
Okay. I think the state law says we have to keep a published book.
We do?
I think so.
But
Aaron?
We don't. And Aaron is saying, yeah, I know we don't.
Well,
what
are you looking at me for?
I'm asking the question because I know we're not keeping hard copy of the code.
I think that's going to change.
Well, that would be good. Therefore, the charter doesn't need to be changed then.
not that sentence. I don't think.
All right. Thanks.
I think that'd conflict. Okay.
Right.
Again, I had a request of. I've had several people ask, what is a newspaper of general circulation? How about I put that on my list of things that we may want to define? Yeah? Okay. Got it.
That one might be interesting because a newspaper of general circulation is discussed in many AG opinions, and you're right, it is a term of art. If you want to define it, that's fine. We'll pull it from.
Yeah, I mean, I'd love to pull it. I don't want to reinvent the wheel. If an AG's defined it or the state's defined it, we'll use it. Or a court, I don't care.
Maybe what we need is just to better the focus needs to be on the ordinance, not the charter here.
It does, but the ordinance may need some guidance. If nobody's happy with how with the newspaper of general circulation they're using now, which I think is Hill Country News or something. I'm not even sure that's meets the definition of within the city. I don't know that it's passed out here. So I just want to make sure whatever we're doing is also consistent with state law, if there is any.
So, yay, nay?
I'm gonna put that on my list of things to possibly define, because there's going to be a bunch of stuff on there. It's a term of art, and if it may be defined, and if it is, we'll use whatever legal authority defined it.
Mr. Chairman, regarding time, where do we want to try to define a stopping point for this evening?
Well, I did, but we ain't going to meet it. Let's at least get to the end of 3, and then we'll take up 4 next time. And as you guys look at number 4 over, I will take any input you want to give between meetings. and try to incorporate it so that we can present whatever your thoughts are to everybody in one cohesive form, is if this is considered cohesive. Okay, but let's at least try to get to 4. So we'll keep cranking here. Frank?
Let's discuss what we're going to do next later, okay? Because, in other words, how we're putting together paperwork for the next meeting. Not paperwork, but information.
I second that.
Yeah.
All right. You want to discuss that now?
No, later, at the end of the meeting.
Okay, fair enough.
Let's get to these.
So it's like, at least let me get to 4, will you? Okay.
Let's do quick yes, no.
Where are we?
3.17, I think we just did.
We're on 3.18. Mr. Hunt brought up the point that the method by which those reasons were calculated, I add that it didn't seem to be objectionable, and I think it helps lock in the rates, just prevents any trickery. If anybody objects, you can let me know, but I'm going to leave it the way it is for the moment. Adoption of code, we changed may to shall, adopt by ordinance and adopt by codification and standard regulations for buildings, plumbing, blah, blah, blah. And I put all adopted codes, trade regulations, standards, and technical regulations shall be referenced and linked on the city's website and made public in a form to allow a competent individual to obtain a copy or view those adopted codes, trades, basically make it available. Frank?
Just to make sure, we think that the city's got to have an ordinance by hard copy. The state law requires the codification hard copy, correct?
I believe so, yes.
Therefore, adding the word shall by ordinance adopt a codification is what the law says. It's a technical issue, guys, about how we go about codifying. Because what used to be done is that when the new codification came in, it was hard copy. This is old stuff, old school stuff. Aaron, you're muted, so you gotta unmute at some point. That new ordinance, the book, the hard copy, would be adopted by ordinance. We are not adopting by ordinance any codification today. It's just being done. So do you get my distinction between a codification that's hard copy and a codification that's electronic? The electronic codification is not being done by ordinance, nor do I think it has to be. The issue is it says shall adopt by ordinance a codification. So is that saying you're going to adopt by ordinance the hard copy of the codification? Well, I'm getting blank looks. That's okay later.
Well, no, who are you asking here, Frank?
I was waiting for one of the attorneys to chime in on that, but I think you're asking a valid technical question.
And
do we have to do the hard copies?
Aaron?
It's just what codification is. It could be 2 different means. And the way this used to be, I guarantee you, when this thing was written, they weren't talking about an electronic codification. They were talking about getting the books.
Well, and that's one reason why they had effective dates in the old days, is so you didn't have to print a new book every couple of weeks. So that
So
Go ahead, Erin.
When you look at Chapter 53 of the Local Government Code, I think it may give some background to what I think Ms. Robbins is asking about. So 53001 says adoption of the code. A municipality may adopt by ordinance a codification of its civil and criminal ordinances, meaning you put it all in a code. It doesn't necessarily mean a book, but we'll get to that in a second in the next section. You put it in a code. So some people we do it under Muni Code. Some people use Franklin as their codification mechanism. Some people have a UDC, Unified Development Code, for portions of their ordinances. So really it's you put it in code form, meaning, you give it numbers, you give it an order. It's a formation of the each of your laws, your civil and criminal laws, because that's what the city's doing. When you adopt an ordinance, you're basically adopting a law for your city, right? So when you adopt that law, instead of just having a big book that has all the laws, you adopt it, you codify it, giving it a number so you know where it is, how to find it, how to cite to it. That's what I think it's referencing. Now 53002 says that publication of adoption ordinance, so that requires you to publish your ordinances. Certain ordinances are required to be published before they can be effective. General rule is anything that affects money, you have to, or a penalty, criminal penalty, fines or fees, you have to publish them before they are effective. It talks about subdivision of a code. It can be subdivided into chapters, titles, articles. It's just about saying that the city may put all their laws into a format that has this structure to it. You can change or repeal an ordinance. It talks about the effect of codification. A municipal code of ordinances has the force and effect of an ordinance regularly adopted in accordance with the law. The record of the code in the municipality's ordinance records is a record of codified ordinances and establishes the content. So it's about creating the record and what format that record is in, how your laws put together and organized. So I don't think it necessarily has to be, I think the section that you're discussing, adoption of the code, that is in reference to the other codes that are outside that we use by reference. The electrical code, the residential code, the plumbing code, those things. I see Frank is disagreeing with me.
Can I cut in for a sec? Because I think
Sure.
I understand his issue. I don't mean to cut you off, but
No, go ahead.
I think what Frank is saying is he's interpreting this to read the city shall by ordinance, in other words, pass a new ordinance to adopt a new code every time we amend the code. Is that what you're
No.
saying? That's not what you're saying either. Okay. Well, then I don't know what you're talking about.
But it's close. Rob,
Okay.
you're close to the issue that I have with this sentence that
Okay.
relates to the prior one. Let me just ask this. Erin, have you ever seen an ordinance that adopted a codification of its ordinances? You haven't. You see what I'm getting at?
So that would typically happen at the beginning of the creation of a city. If you have a city, you just form, you have adopted some laws, and you want to put all those laws into a code, you want to codify all your laws. I haven't seen it happen because I'm not that young, unfortunately, or not that old. But I think in theory it could happen, but it is not something that I think any of the ladies and gentlemen on this panel would see, because unless we're creating a new city, you typically wouldn't do that. There are a few cities, I will tell you, that have not codified all of their ordinances. There are some out there. I've come across and worked with a couple. And so if you want to look for an ordinance, you've got to dig through a list of all their ordinances to find the most current one. They don't have it adopted into a specific code. It's not on Municode. It's not, they don't have it in the format number wise. They just have a list of ordinances that they've adopted. Is that what you're referring to, Frank?
No.
Okay.
And I'm with Christina. Let's move on. I'll visit with you and or Rob on this issue to try to indicate that we're not the way the charter would be written. We are not doing that. If you put the word shall in there, we're going to have to change the way we do business.
Right.
Okay.
Okay. And I think I put the word shall. I think I put the shall word in there after discussion with you. You indicated it should be shall, right, Aaron?
No. I would prefer to have, as Christina's indicated, for reasons that we previously discussed, I think it'd be great to have a hard copy that's at a date certain. A lot of stuff you can put in your ordinances that we don't do now, make it easier to find. One of them is to have a hard copy in a given date, and I think that's useful to have. But I don't think the charter ought to require that we adopt an ordinance, the code of ordinances. That's all. It's a preference of how we should do it as opposed to charter change.
Well, we already got a code of ordinances, so it's been adopted at some point, I would assume.
Each ordinance has, but the whole thing hasn't. We quit doing that some years ago. We used to get the Municode book. You with me?
Yeah, and then you'd say, yeah.
And then when it came in,
you'd say, this is our book. Okay.
Yeah, the whole thing. The
Okay.
staff would actually, years ago, the staff actually began reviewing that document to make sure that it had all the changes in it. And the staff would find corrections, go back to Municode. They'd fix it. We'd get it. It'd put on the council agenda, adopt it. Boom, go. Next.
Okay. All right. I don't know where that leaves us.
Later. Let's go later.
All right. Let's see. 3.21 has the allowance for council to appoint a designee to do some investigations if it needs to, without stating that it's creating anything new. It can bring its report back to council or to whoever council tells it to. And basically the designee would be essentially an agent for the council and would only have the authority it gives it. But I don't think I need to put all that in here. Okay. Say no, nothing on 322.
On 321, sorry.
Oh, go ahead.
Should it have a responsibility to investigate something that comes up?
I don't know, and I think that's going to, if we have that, it's probably going to wind up in the code of ethics. Okay. When I was studying law and preparing for the bar exam, we have to take a special exam on the ethical portions of being a lawyer. And the easiest rule to remember on being a lawyer was the duties that that's required of you one of the biggest duties you have is to rat out your friends. If we see a lawyer that's doing something unethical that violates our rules of ethical conduct, we have to report them, or we're violating the ethical rules of conduct. And so I think that duty, if it exists, should be in the ethics portion of the ethics policy of the city, which is a function of council more than the charter. But that it's a really good point, and you know, if a city councilman hears of something that he believes is unethical or improper or illegal, does he have a duty to bring it to somebody? If so, who? And if they don't do it, is that a violation of themselves? I don't know if it's in there. I haven't read it that closely.
Okay.
But
thank you.
But that's when groups have to police themselves, that's something that is usually in there. The rat out your friend clause.
Well,
Okay.
especially, I mean, in this whole document, we're giving the city council and the mayor so much power that I would hope that they would have that responsibility. So that's just that. Thank you.
But we certainly do hope they conduct themselves in an ethical fashion. And it's not always easy. Okay. Prohibitions, we get down here, it says no member of council should give orders directly to the city manager. We've discussed that already. Is everybody good with that? And should we, well, we're not to the councils, the individual councilman yet, I don't think so.
I
yeah,
did
we
just
are.
have some commas or something just to better break that section up a little bit. The council shall have powers only as a body meeting. It just kind of sounds weird.
Shall have powers only as a body meeting with a quorum present. I think I would put a period there if I was really going grammar Nazi on them. I think I would really put a period there and start a new sentence with no member shall have power to act individually. But that's that's me. Any member is free to take a grammatical shot at rewriting some of these. I'm not a grammar wizard. I run everything past my wife, who was trained by the Jesuits, so she's the designated grammar wizard in our house.
Thank you.
But yet, if you want to take a shot at cleaning that up, I'm along with it. The only other thing is, do we want to give the city councilman the same powers that we gave the mayor, and that is to consult and advise with the city manager? Frank does. I think I think that's let's Frank, between now and next time, let's see if we can find a good place to stick that in, because there's not really a good spot in there unless there's a list of, let's say, things that the councilman can do that I missed. Removal. Nope. Mayor. I don't think we're to them yet. I don't think we're to the council yet. Okay. That gets us to 4. Have we thoroughly beat up 1 through 3 to where we can move on to 4 next time and go forward from there? Yes? Okay. All right. Due to the limits of time and constraints of people having to get up and go to work tomorrow and be on a Zoom call with a court in the morning. We will table number 3. Frank, you wanted to discuss something up about future. Oh, did I get the copy of the minutes out to everybody?
I haven't seen them.
I just couldn't. I don't remember if that was part of my deal. So we may have to table that until next time. Let me see what I sent everybody. Tonight's meeting. Let's see. No, I did not. Okay, so you don't have them, so we can't approve them. Can I have a motion to table the consent of approval of the minutes till next meeting? Got a motion from Carter, second. Gage. Okay. Everyone in favor of tabling the approval of the minutes of the April 19th minutes to our next meeting?
Aye.
Aye. Unanimous. Okay. Frank, you wanted to consider future committee meeting stuff? You had something?
Yeah, this has to do with all the work you're doing to put together stuff gets sent to you.
Yeah.
And some of that stuff's getting to you. Well, some of that stuff's coming to you late.
Yeah.
And so if we're going to build a packet, or you're going to build the packet of stuff to get out, personally, I would like to get that at least by the Friday before. But I don't know when you need to get it if you want to get it out by that period of time. That's one. Let me throw out a couple of that's one.
Okay.
2, one option might be for us, if folks have got something to say, email it out to all of us.
Sure.
And nobody replies. You just send it out. Whenever you get it, well, I shouldn't say whenever, because maybe we'll send a deadline of when you can send stuff out.
It'd still be nice, to Frank's point, to see what other people are thinking. And that was, for example, my intention when I emailed everybody on the committee, the notes I made to myself. You don't have to make an argument for the position, just a note. What caught your attention? What did you think was worthy of further discussion amongst ourselves? And go from there.
And I did the same thing with my own stuff, and I tried to incorporate Gage's into a single document, so you don't have to have 4 copies of the damn thing on your desk.
Hey, Rob, with you being chairman, would you mind just forwarding to the committee any requests that you think we would want to see?
I'm actually going to tell you what, if I can get our next meeting is, let's see, the 2nd Monday in April, which will be or the 2nd Monday in May, which is the 10th, I believe. Is that correct? If I have, if everybody, we need to have an agenda. The city likes to get them out a week in advance, so I will try to have the agenda prepared by the 3rd, and whatever material I get, I will put in a package of supporting package, including the stuff I've already received, and send it out as a packet. Any new material that I get between now and then, and it'll be, sometimes people make suggestions and they don't necessarily really want anybody to know who made it, and that's fine, because
well, they don't necessarily have that privilege under the open records request.
Yeah.
That's true. Well, if they show up in a meeting,
something, They need to understand they're going on the record.
That's fine. That's
Hey,
fine.
Rob,
Yeah. And
is
a
there,
lot of a lot of it's just verbal. Somebody will say something. Yeah, go ahead, Gage.
Rob, is there a way to put up a master copy of this document that's in progress for us that we can all access and make comments on?
Well, yeah. I mean, the master document is essentially the one that I've sent out for tonight.
But I meant, but right now the way it works is we all have to funnel what we're saying to you so that you can consolidate everything into what we're going to talk about. Is there a way to put up on a website somewhere in Google Docs or something like that, put a master up of the charter in progress that we're working on that we can all put our red line comments onto, or put our comments onto, so you don't have to consolidate them and we don't have to wait for that consolidation to see what everybody's thinking?
We can. Well, I'm not sure. That may actually be a meeting.
Open meeting.
Yeah, that might be an actual violation of the meeting. I'd be concerned about that for two reasons. Number one, violating the Open Meetings Act, which I don't even want to come close to. And number two, I'm afraid we'd wind up with a god-awful mess of with a lot of stuff, because I know there have been comments, and I mean, I think, Gage, you know, when you submitted yours, you and I talked, and there was a couple of times where you just had a question about something that I was able to answer, and you said, oh, okay, yeah, let's not worry about that. And Christina and I did that too, and you know, so I'm trying to keep as clean a copy as we can, but what we can do is I can put out the document that we have now, and I'll try to get one out by tomorrow afternoon after taking into everything we've talked about tonight. And I'll try to get that out to everybody, and each of you can make separate changes in Word, and then if you want to, I can consolidate all those and redline them and see what sort of a spaghetti colored mess we wind up with. It may be totally unreadable when you get that many people involved, but we can give it a shot. I'm certainly willing to try. And,
well, I certainly am not recommending anything that the rest of the group doesn't by consensus think we ought to do. If they feel like, you know, that's not the right direction, let's not go there. I just know that it was a process that worked for me in other situations where we had multiple people working on the same document.
Yeah, we have that all the time in the legal practice, but we aren't constrained by the Open Meetings Act, and generally we're all focused on very specific terms of a deal or something. But you know, I'm certainly capable of comparing 6 documents if we wanted to and see what everybody's changes were. But I'm not sure we'd be able to read it once we were done. So that's kind of why I thought if I could do a consensus document or kind of where we are now, and you have your own, it's easier for you to compare yours to theirs without the other folks coming in, and then we bring in the other folks at our meetings. But
it was just a thought, whatever works for the group.
It was a good one. I'd be concerned about the Open Meetings Act on that one. Frank?
Rob, it's your preference for you. Would you rather get a track change document, or would you just want to get comments from us? In other words, the track change, Paul put, and I like Paul's deal. I just hadn't read it much before the last meeting, where he made his comments on the charter.
Yeah.
Using track change. Is that what you want from us?
That's fine. Yeah. Yeah. I got that from Paul, and I got that from Gage as well.
Okay, that's why I'm gonna send it to you.
Yeah, and that's fine.
Okay.
As long as it's using the word review functions, we're in good shape. But if you don't know how to use those, and if people aren't lawyers and don't write a lot of contracts and things like that, a lot of times they don't even know how to make those red lines show up. So
what YouTube is for.
What's that? Yeah, that is what
YouTube's for. How to red line Word doc.
Yeah, you can build a rocket with YouTube instructions these days. So but I don't want to. If you just want to send comments, I'm okay with that too. But and I'll incorporate them as truthfully as I can, and then I will just know that I will eventually put them in a package so that everybody can see them, which hopefully will be next week. But since we're meeting on if everybody gets their information to me by this upcoming Sunday, then I should probably be able to get it out on a Monday, and we'll be able to have not only a agenda but a packet. And I've been wanting to do that, but heck, last week I was getting changes at 5:30 and suggestions, and so, but we'll get her done. Yeah, Paul.
I'd like to make a motion that we adjourn.
Are
we there?
I'm open to that motion. Do I have a second?
Second.
Oh, hang on a second. Don't vote. We do have to put something on the future meetings. Christina has informed me that after our next meeting, she will not be able to. Her other obligations are such that she doesn't believe she can handle the minutes and the responsibilities that go with being a secretary. So we will need to elect a new secretary next week, in 2 weeks. So that will be an item on the agenda for sure. Anything else need to be on that item on future meetings? Okay. Mr. Roberts, you can assert your I'll reassert your motion for you. There was a second. All in favor of adjournment?
Aye.
Aye. All right. Thank you, gentlemen and ladies.
Hey, Rob, this is a lot of work. I think everyone appreciates it. This is a hard committee to chair, a lot of detail and stuff. So thank you.
It is, and we have good attendance and good attention to details. So it's